Welcome to the Sui Generis Show, your unique perspective on everything related to your civil rights and the criminal injustice system. I'm attorney Brian Jones with Erica Merrill. Today, in segment 1, we will be discussing the effect of former President Donald Trump's last-minute pardons, prosecutorial misconduct at trial, resulting in an overturned conviction in New Jersey, and the position letter submitted to Congress by 135 individual civil rights groups advocating against new domestic terrorism laws. During segment 2, as promised, we'll be getting into part 2 of our discussion of the death penalty and talking about how the death penalty is imposed and the relationship between the death penalty and due process. Make sure you don't miss an episode by subscribing on Apple Podcasts, YouTube, and Spotify. Follow our social media channels and look to the law office of brianjones.com for everything you need to know about your civil rights and the criminal injustice system. So Erica, did you see in the news this week that rapper musician Lil Wayne and Kodak Black were among multiple individuals who received pardons during the final hours of the Trump presidency?
Wow. I mean, I actually hadn't seen that part. I knew that he was pardoning people. And I even saw somewhere where it said he was selling pardons for tens of thousands of dollars, and those were being brokered. I mean, is that true? Is that legal?
It would be absolutely illegal for the president to sell his pardons. There hasn't been any significant evidence other than rumor and innuendo that he was actually doing that. If he was, I'm sure there will be an investigation that would uncover it.
Wow. Well, I guess they'll just add that to the list of investigations then, because I know that there's a lot of work to do on some of the craziest things that have been happening during the last 4 years, which were protected by the presidency, by the office of the president. But now maybe you could explain the difference between a pardon and clemency for those of us that don't know.
So clemency is the general umbrella term for two different types of executive relief. And by executive, we mean the executive branch of the government. In the United States federal government, we're talking about the president. The state governments, we're talking about the governor and all of his associated offices. Now, the executive branch can give someone convicted of a crime a pardon and or a sentence commutation. Now, the president can also issue clemency for federal crimes, whereas governors can issue clemency for state offenses. A pardon forgives a crime after the completion of a sentence and usually requires some sort of meritorious reason to do so, including acceptance of responsibility or demonstration of remorse, demonstrated good conduct after conviction or release from prison, and a pardon does not establish innocence. Now, the states and the federal government have their own individual and unique timing requirements. And generally, we're looking at a 3 to 5 year time period after successful release from supervision. Waivers can be granted to those time periods in exceptional circumstances. Now, the other type is a commutation, and the commutation is the reduction of an active sentence. Now, unlike a pardon, a commutation does not excuse or otherwise justify the underlying crime, and it can be used to reduce or eliminate everything from the period of incarceration or jail time that a person has to serve, all the way to their fines or the restitution amounts that are still in effect and outstanding.
Wow. So I feel like it's a lottery ticket for some of these people. When clemency is granted, how long does it take to go into effect?
Well, to get clemency or a pardon is absolutely hitting the legal lottery because it is so rare to happen. Once a pardon is issued, it's immediately effective as soon as it is served. There's actually some very Well, from our perspective, funny stories, probably not funny from the person that was in prison, of situations when Ulysses S. Grant issued pardons. The subsequent president revoked those pardons, and the pardons had not been delivered by the warden to the inmate, and so the pardons were found to be null and void. Now, pardons can be used in active cases, active investigations, such as the situation with presidential advisor Steve Bannon, who was presently under investigation for misuse of campaign funds in relation to funds that the Trump administration was gathering for support of the border wall. Now, in that situation, there can either be a sua sponte, in other words, on the motion of the court itself, or a government filed dismissal of any pending charges or the closure of those files. Now, pardons in closed cases like that of Kodak Black will result in his release from custody. It's important to note in Kodak Black's situation that the state of South Carolina would like to get custody of him, wants to take him into custody before he is released from federal custody, because he is under investigation for sexual assault in the state of South Carolina. Now, this is an important thing to note. So Kodak Black is presently serving a federal prison sentence for a gun crime, and he is under investigation for a state crime of sexual assault. So the president cannot do anything about these state allegations. He can only pardon the federal offense. Now, a sentence commutation is also immediate. It takes place as soon as it's signed. And obviously, there is some time period that has to be completed for the execution of the paperwork. But a commutation typically eliminates things like probation and other post-conviction or post-release supervision. So once the individual is released, so long as there are no other obligations that they have, all of their obligations to the government are over.
Wow. I mean, that is so interesting. Is the pardoned person protected by double jeopardy?
Person that's been pardoned is protected by double jeopardy for the charges filed by the jurisdiction from which he received the pardon. So, using Kodak Black as the example again, he is now free from federal prosecution for the gun crimes that former President Trump pardoned him for. But remember, he's got state charges for an unrelated matter pending, and the conduct that landed him in federal prison could also be a state offense. So the state in which he picked up those federal gun charges could presumably prosecute him for that same conduct. Now, the same thing applies to a person who receives a state pardon or a state governor's pardon. Each executive has their own power only within their own jurisdiction.
It sounds like it gets really tricky, and it's probably good to have an attorney for situations like this.
Yeah, Erica, you can absolutely have an attorney help you fill out the paperwork. Now, for the state of Ohio, the petition for a pardon must actually be signed by the petitioner, him or herself. So while an attorney can help you fill out all of that paperwork, gather the most compelling evidence in support of your pardon, ultimately you have to file that document on your own. At the federal level, again, you've got the same situation where it's very important that you have the involvement of an attorney to make sure that the right information is given to the president when seeking your pardon. So, Erica, did you see this story out of New Jersey this week? A prosecutor had compared a defendant to Jack Nicholson's character from The Shining during closing argument, actually posting on the overhead projector in the courtroom the image of Jack Nicholson bursting through the bathroom door, screaming, "Here's Johnny," in his psychotic break during her closing argument on a nonviolent burglary case.
I mean, I'm speechless. That's unbelievable. Are attorneys allowed to talk about pop culture, like movies and songs during a trial?
So it really depends on the context. A particular film or a song or a story could absolutely be relevant to either the prosecution or the defense's theme and theory of a case during the course of trial. A prosecutor could use an artist's song lyrics or album art in explaining or analogizing particular charges. Now, by that same token, the defense can use imagery from film and song through cross-examination, through jury questioning, the process known as voir dire, or closing argument, in order to explain and really make their theory and theme of the case robust for the jury. But in all of these cases, the lawyers in a trial, defense and prosecution alike, must keep these sort of metaphorical, allegorical connections related to the case and within the bounds of the law in all the other circumstances. In Damon Williams' case, when the prosecutor compared him to Jack Torrance, Jack Nicholson's character from The Shining, she was implying that he was a violent individual. Now, the prosecutor knows very well that she's not allowed to bring in other convictions, even if they're violent convictions. She's not allowed to make allegations that aren't supported by the evidence. There are a whole set of rules called the rules of evidence that limit what she can present to the jury in order to make sure that people are convicted for what they actually did and not what they did in the past. That whole theory of once a thief, always a thief is absolutely inappropriate inside of a courtroom. So she knew very well that she couldn't legitimately compare him to a violent individual. And when she did in this situation, knowing that this burglary was not a violent crime, she really overstepped the bounds and broke the rules in a variety of ways.
So, how was the behavior preserved to the record by the defense attorney?
The prosecutor had made this comparison to a would-be axe-murdering psychotic during her closing argument. Now, granted, attorneys do have some artistic license, but as we discussed, this is a gross abuse of that privilege. The defense counsel in this case immediately and appropriately objected. There was a discussion held at sidebar with the court as to how they could possibly cure this terrible miscarriage of justice. And ultimately, the judge decided that a curative instruction saying, well, you should just ignore that. Don't listen to the bell that you just heard wrong. And that would be sufficient. Well, the jury convicted Mr. Williams on the more serious charge that included threats and acts of violence during the course of a burglary, even though there was no evidence at trial that he threatened or was violent during the course of the act. The defense counsel made sure that there was an appeal pursued on the basis of the prosecutor's misconduct. That appellate process landed Mr. Williams' case in the New Jersey Supreme Court, who concluded that prosecutors especially have to walk a very fine line when making these comparisons between a defendant and an individual whom the jury associates with violence or guilt in general. The use of sensational or provocative images to make that comparison, even if metaphorical, creates a heightened risk of improper prejudice that can affect the jury. And the Supreme Court of New Jersey said, in this case, it went too far and it was unacceptable. So they reversed Mr. Williams' conviction and sent the case back to the trial court for further proceedings.
So, I'm assuming that the prosecutor was not punished at all for this.
They never are, Erica. They get away with this sort of behavior over and over and over again. And what we find is that not only do they get away with it, but they get promoted because they're able to cheat their way into victories.
So what will happen to Damon Williams now that his conviction is overturned?
So the prosecutor's office is going to have to decide if they're going to retry Mr. Williams. The conviction was overturned due to the prosecutor's prejudicial comments, but the court did not make a decision on the legal sufficiency of the evidence or the manifest weight of the evidence, which are topics that we're going to cover on this podcast in future episodes.
Well, I'm looking forward to hearing about what happens in the future. And it is kind of a bummer that you have the cards stacked against you like that in a trial where, the other side gets to play dirty tricks and get away with them.
Well, it really is. It's an unfair situation, and prosecutors are the only category of lawyer that has a disciplinary rule written specifically for their area of practice. Every other lawyer on the face of, well, I guess I shouldn't say the face of the earth, every other lawyer in the American system has an obligation of absolute fidelity to their client. And within the bounds of the law and within the rules established by the courts, must do everything in their power to win their client's case, whether they believe in it or not, except for prosecutors. Prosecutors have been specifically charged to do justice, not simply win convictions. But the number of prosecutors that I see every day in my practice of criminal defense that absolutely abandon that edict is disgusting.
Yeah, I absolutely agree with you. And, kudos to you for being able to handle that. And, you really need to have an attorney that understands the strategies of the other side so that you can object when something out of the ordinary happens that is going to tilt the scales in the wrong direction for the wrong reason.
Yeah, that's absolutely true. And when we come to that ends justify the means mentality that we see so often in the law enforcement community, it can really work a significant injustice for everybody involved. Everybody from the defendant to the accusers to the rest of society um, in that jurisdiction. Speaking of government overreach, Erica, did you see this week that 135 civil rights organizations signed on to a letter urging Congress to refrain from writing new laws that could be used as abuse for religious and racial minorities? They wrote this letter against new domestic terrorism laws.
That is absolutely unbelievable. It's great news. How the heck did they get so many organizations to come together to make this happen?
Well, the Leadership Conference on Civil and Human Rights is a nonprofit organization comprised of more than 200 national organizations that protect and promote civil and human rights of all persons in the United States. Now, it was founded in 1950 and has coordinated national lobbying efforts on behalf of every major civil rights law since 1957. This particular letter was organized by the Leadership Conference on Civil and Human Rights. Now, the organizations that supported and signed on to this letter to Congress include a huge cross-section of religious organizations, immigration advocates, LGBTQ organizations, legal organizations, civil liberties organizations, including but not limited to groups like Common Cause, Drug Policy Alliance, the NAACP, the ACLU, the National Organization for Women, Restore the Fourth, and Sisters of Mercy of the America's Justice Team. So it really was a broad cross-section of every interest group in America signing on and saying, we have enough laws on the books. We do not need to add new crimes for police and prosecutors to enforce.
I mean, that's unbelievable. And I guess it does make sense that they had a big conference and they were able to address the issue and get some things done. Usually conferences aren't as productive as that.
You're absolutely right. It takes a huge effort to get this many people, and especially from groups that often have antagonistic positions, to come together and support a common cause.
So what were some of the main concerns that were addressed by the letter?
So, Erica, the failure to confront and hold white nationalist violence accountable is not a question of having the appropriate tools to employ, but rather a failure to use the tools that are already available on hand. There are over 50 terrorism related statutes that can be used to investigate and prosecute criminal conduct that stems from white supremacist violence. The letter in particular opposes the Confronting Threats of Domestic Terrorism Act, or House Resolution 4192. It was introduced in 2019, and it would establish a brand new offense defined by someone who commits a violent crime, quote, with the intent to intimidate or coerce a civilian population, influence the policy of a government by intimidation or coercion, or affect the conduct of a government, covering crimes such as kidnapping, murder, assault with a dangerous weapon, as well as property damage that creates a, quote, substantial risk of serious bodily injury to another. Now, these organizations join members of Congress, including Rashida Tlaib, who issued their own letter in opposition to the law and stated that our history is littered with examples of initiatives that have been sold as being necessary to fight extremism, but they quickly devolve into the tools used for mass violation of human and civil rights of the American people. Now, you'll recall, for example, Erica, our collective shock when it was revealed by Andrew Snowden, albeit illegally, that the United States government has been using its 9/11 powers of surveillance to monitor American citizens on American soil for non-terroristic purposes. This sort of government overreach is exactly what we're concerned about. And Erica, I have this conversation with individuals all the time, and especially individuals who are really over the age of about 35, 40 years old, people that are in their 50s and older. They have this thought that the police are here to help, and that the government only wants to get involved when it's absolutely necessary. But Erica, the events of September 11th changed that mentality forever. And the government has now taken a significantly more active role in monitoring us, in surveilling us, in restricting how we can act and behave. And I think that's really dangerous for freedom in general and the American ideal in particular.
Well, that's really very interesting. And, I know we're making a lot of strides in the criminal justice system reform. Like, how does this fit in?
So this is a great recognition that we don't need more laws. We need adequate and equitable enforcement of the laws and the tools that law enforcement already has. It's policing and prosecuting that need reform, not statutes themselves. White nationalists and white supremacists and their movement have been growing for decades, flourishing under both President Obama and President Trump's administrations, despite the FBI sounding the alarm bells. How police and prosecutors decide to handle this new terroristic threat can and should be affected and enforced in the next frontier of the modification and reform of the criminal justice system.
I mean, I think it's enlightening and it is inspiring to see. So I'm really happy that they're going forward with this.
And with that, Erica, let's turn to our featured topic this week. Now, the death penalty is the most severe of punishments. Once somebody's life is taken by the government, there is no appeal or way to reverse the harm if it's done improperly. The death penalty, we found out last week, is not cruel and unusual punishment as defined by the Supreme Court of the United States, but it is subject to very strict federal and state constitutional requirements. Today, let's dive into proportionality, procedure, who determines when a death penalty can be imposed, and move forward with segment 2 of our discussion of capital punishment in America.
What is the proportionality requirement?
In 1977, the Supreme Court of the United States decided Cocker v. Georgia. Now, in that case, the Supreme Court held that all penalties have to be proportional to the crime. Otherwise, the punishment does violate the Eighth Amendment's cruel and unusual punishment prohibition. So the proportionality test that was decided in that case, or that was outlined in that case, has 3 factors: the gravity of the offense and the stringency of the penalty, a consideration of how that particular jurisdiction punishes its other criminals, and a consideration of how other jurisdictions punish that same crime. So what we're looking at is, how serious is this offense? Are we going to execute somebody for a speeding ticket? Is that too strict of a penalty for the offense? That's the first question. The second question is, how does this particular jurisdiction punish other crimes? So if we have theft of a stick of gum and a speeding ticket, are these crimes similar in nature? Are they treated similarly in nature? Or maybe more adequate, maybe more appropriately for this discussion, we have murder and murder in the second degree. How are these crimes punished? And is the punishment for the less culpable murder in the second degree actually a lower penalty than the more culpable first degree murder? And then the last consideration is how other jurisdictions punish that same offense. So for this, it's really nice to look at Kennedy versus Louisiana. That was a 2008 case that the Supreme Court decided that extended Coker. Now in Kennedy versus Louisiana, the Supreme Court looked at that third prong of the test, and it said, well, there are only 6 states in the United States that allow execution for a conviction for child rape. And the Supreme Court of the United States said that the national consensus on this is that the death penalty is disproportionate for this particular offense. And so the Supreme Court said, Louisiana, you cannot impose the death penalty for child rape. And this developed because somebody was convicted of a capital sex abuse crime, and they appealed and fought for this result. Now, in Ohio in particular, the death penalty is only available for very particular types of murder. Life without the possibility of parole is available for those convicted of child rape in Ohio and is mandatory. A mandatory life without the possibility of parole sentence for a very small set of cases, which are situations where there is a victim under the age of 10 years old and force is used.
I mean, that makes a lot of sense. I mean, one could, I'm sure there are people on both sides that think, hey, let's just burn them all. But I mean, it's true. They don't kill everyone, as we discussed in some of the past ones. If you murder somebody, they don't always give you the death penalty. So it would make sense that if there was a sex crime, as long as it wasn't a brutal one, which, I know people, it's so hard to talk about that without, especially with children, without feeling like we'll just burn them. But I I can see where it's good that they have a comparison and that they're trying to keep things proportionate to the crime when they are punishing people.
And that's the requirement of the Eighth Amendment, is that proportionality. And really, we as a society, the United States in particular, North America more generally, have started to shun capital punishment. Certainly, the Western world has largely shunned capital punishment as a consequence for any crime. And there are a variety of reasons for that, not the least of which is the fact that the United States has almost certainly, even in the modern era, executed an innocent person.
And that is so true. And we absolutely want to make sure that, that there wasn't a false accusation, which does happen, and then somebody gets killed. I mean, that's horrible. At least if it's a situation where they're in jail for a long time, the case could be overturned if they find new evidence that proves them innocent.
Precisely.
So what procedures have to be followed in a death penalty case?
Well, I think that's a great question, Erica. The procedures that are in place for that exact situation that we just talked about. The possibility that we want to avoid at all costs of executing an innocent person. And the due process rights that are offered or available in a capital case, in a death penalty case, are increased from the very beginning over and above what the government must do to convict and incarcerate a defendant for a non-capital offense. A capital specification is the first thing that's required. And in that situation, the grand jury has to find very specific reasons over and above the basic crime. So in the United States now, persons can only be executed for murder. But it has to be murder with something else. So the first protection is the grand jury has to find that something else. And the capital specification then triggers a variety of additional rights, including increased funding for the attorneys that will represent the accused, multiple attorneys in most jurisdictions, funds for private investigators, testing, medical testing, and a mitigation specialist, somebody that can help coordinate the argument in favor of life, and rights to additional discovery that may be unavailable in a non-capital case, like children's services records and records that are typically protected by rape shield laws. The capital trial is even more particularly, once we get into trial, granted a variety of additional safeguards. The first of which is extensive and frequently individualized voir dire. In other words, the panel of jurors that are brought into court to decide guilt or innocence, death or life, are then brought in individually, one at a time. And the defense attorney and the prosecutor get to ask them questions one at a time, in order to make sure that we pick as unbiased a jury as we possibly can. The capital case is bifurcated. And what that means is that there's a guilt phase and a punishment phase. So first, the jury has to decide, has the prosecution proven this case beyond a reasonable doubt? Then the prosecution, if they are able to secure a conviction, a guilty finding, must then convince the jury that death is the appropriate consequence for that crime. And that is unlike any other criminal trial, particularly in Ohio. There are some jurisdictions that do allow a jury to decide punishment, but Ohio is not one of them. Now, the United States Supreme Court decided in 2002 that it is unconstitutional for a sentencing judge sitting without a jury to find aggravating circumstances to impose the death penalty. And what that means is that a defendant in a death penalty case has the right to have a jury decide beyond a reasonable doubt that the government has proven sufficient facts to warrant the imposition of the death penalty by finding those aggravating factors, those specific additional factors that make this particular crime particularly heinous. The defendant has the right to present mitigation during that sentencing phase of the trial, and they have the right to have money and funds to gather and produce that evidence. And the defendant's ability has to present evidence is wide ranging. There are almost no restrictions on what the defendant can present and what their attorneys can argue when making the case for life. Now, a defendant that is found guilty of a capital crime and who receives the death penalty has additional appellate rights, both at the state and the federal level, including a variety of avenues for appeal, reconsideration of the sentence, and collateral attacks on both the conviction itself and the sentence in particular.
I mean, it makes a lot of sense that you get a lot of extra tools to help fight for your freedom, especially if this was a false allegation. And I'm really happy to hear that a judge just can't sit there alone in a room and make the decision himself on something as big as somebody's life. So who really does make the decision?
So at the foundation, the trial judge makes that determination by hearing the evidence and making determinations about the lawfulness of the charge, ruling on evidentiary issues. Is this information reliable under the rules of evidence? Is it admissible under the rules of evidence? And controlling the selection and questioning of the jury. All the way back to the beginning of the case to the funds that are provided to the defense in order to investigate and present the defense case. From a position of who really has the ability to influence a death penalty case, the defense attorney is a very particular player in this process. In particular, they have to be highly qualified and specially trained. There are very specific rules in every jurisdiction about who is qualified to represent somebody who is accused of a capital crime. And the attorney will be making a record from the moment the case is filed, ensuring that every possible error is preserved for appeal. Now, the attorneys in our office are capital qualified. I am a capital qualified attorney. And so I make sure that while I have not represented an individual accused of a capital crime, I make sure that I handle all of my cases to the best of my ability as if it is a capital crime. And I want to make sure that every stone is overturned in all of my cases. In capital cases in particular, the jury weighs the evidence presented by the government and decides first, is the defendant guilty beyond a reasonable doubt of the charged offense? And then second, are there sufficient aggravating circumstances to warrant the imposition of the death penalty? So in that regard, the jury makes a determination if the death penalty has been legally imposed in a case. After a jury imposes a death sentence, the Court of Appeals will hear the appeal from the trial court and review all of the rulings. And then that is followed by the state Supreme Court in most states. Now, in Ohio, capital sentences are appealed directly to the Ohio Supreme Court. Now, once all those state avenues are exhausted, a capital defendant will pursue federal remedies like habeas corpus and appeals to the Supreme Court of the United States. Ultimately, the Supreme Court of the United States is going to be the final decider on whether a person can be legally put to death.
Wow. I mean, it sounds like they have a lot of great processes put in place. And, I'm really happy that you were able to explain all of this to us today.
Well, you're welcome, Erica. And I appreciate you engaging in this very difficult but very important discussion with me. And I want to thank everybody who took the time to listen and watch our show this week, and remind you that in order for you to stay informed about the latest updates about the hottest stories in civil rights, police and government accountability, and the criminal injustice system, check out the law office of brianjones.com and click on our blog tab. Find us on facebook.com/Central Ohio Criminal Defense and on Twitter, Instagram, and TikTok at TLOBJ. We'll be back next week with a sui generis perspective on the next big thing in civil rights and the criminal injustice system, as well as a discussion of who can receive the death penalty and how the death penalty is carried out. Erica, my grandfather always told me when we parted ways, don't do anything I wouldn't do, young man. And to that, I add, when parting ways with all of my friends, if you do and you get caught, call me. I'll defend your rights as I would want mine defended.